Hello, I'm Naomi Korn. I'm going to talk to you about good practice in rights clearance and licensing for OER projects. You have been funded by JISC or HEA in order to create OERs which are ideally reusable and repurposable. This will have an impact upon the rights clearance and licensing options that you will choose in order to ensure that you can enter into the wonderful world of Web 2.0. Now let's see what some of the key issues are along the way in terms of your rights clearance roles and responsibilities in order to try and ensure wherever possible that your OERs can be repurposable and reusable. There are likely to be lots and lots of different layers of rights in your OER which need to be identified, and downstream permission will need to be sought from rights holders if you haven't already got the necessary permissions in order to ensure that your OER can be reusable and repurposable. You can use this chart in order to help you understand the different types of rights issues which may exist in content which forms part of your OER. Over the course of the next few weeks, we'll be replacing this flowchart with 3 flowcharts which we have specifically created for OER projects. OER projects will use licenses in 2 different ways. They'll use licenses to secure permissions from third parties who own the copyright and for whose content they wish to use as part of their OERs. They'll also use licenses in order to ensure that their OER can be ideally reused and repurposed by end users. It is vital to ensure that any permissions that you have sought from third parties are compatible with any licenses that you grant to end users to be able to reuse or repurpose your OER. In other words, you cannot license out more permissions than you yourselves have sought from third-party rights holders. This very much affects the types of rights that you need to ask from rights holders in the first place. How do you ensure that the rights that you grant to end users are compatible with the rights coming in from third parties? Well, one of the most successful ways that you can ensure that this is the case is by choosing your Creative Commons or similar license before you start your rights clearance procedure. In order to ensure that your OER can ideally be reusable or repurposable, there are 3 different Creative Commons licenses you can select: the Creative Commons Zero, the Creative Commons Attribution, and the Creative Commons Attribution Share Alike. Now there are circumstances in which you may find that your OER cannot be made reusable or repurposable. These might include situations where your OER includes third-party rights for which permission you haven't sought, clinical or sensitive material, or it might just be anti the policy of your own institution, and in those circumstances we recommend that you talk to your strand manager. But if you are going down the route of ensuring that your OER can be reusable or repurposable, by choosing your Creative Commons or similar license, such as a government open data license first, you can then ensure that the permissions that you seek from third parties is compatible with the end user license that you have selected. If you want to find out more about this particular theme, you can go onto the OER IPR web pages, you can go into the OER IPR starter pack, and in there is a little video in which I'm describing in more detail the process that you can put in place to make sure this is possible. You'll also be able to download from our OER IPR starter pack a template rights clearance form and a template consent form, and in there we have highlighted the areas where you can already suggest to rights holders the type of Creative Commons license that you wish your end users can make of your OER to ensure that your rights in and your rights out are compatible. Consider your rights clearance strategies as part of your overall project. In other words, you need to allocate time and resource to sort out the rights properly. Understand exactly what your project wants to do with someone else's content, and also ensure that you're clear about the license that you are granting to your end users. What does that allow? What does that not allow? Once you've done this, identify whose permission you need to seek. Is it students? Are there freelancers or contractors whose work you wish to use for which you haven't already sought permission? Are you wanting to use content that's already on the web? Maybe it's been licensed under Creative Commons license, but maybe the license under which it's been already made accessible and usable isn't compatible with the license that you yourselves have selected to provide access to end users. If you do need to seek permission from third parties, make sure that you tailor-make your requests according to your audience. Explain what your project is, talk about the benefits, get people on board, make it easy for them to agree, make it easy for them to give consent by either enclosing a stamped addressed envelope if you're sending a request by letter, or maybe send a request by email. Make sure again that permissions that you ask from third parties are either more or the same than the permissions that you are then granting onto end users. If they're less, you will be infringing copyright, and you'll also be providing the means for other people to infringe copyright. Be clear about what JISC or HEA expect from you in the funding agreement. Finally, make sure that you manage your rights properly after you've sought permissions, after you've got the permissions you need. Set up a database that's then accessible after the lifetime of your project. Give yourselves lots of time. Be aware that there may be works where you can't trace the rights holders, or rights holders are unknown, and then you need to consider other issues, and we'll cover those in a moment. So, if you can't trace rights holders, or the rights holders are unknown, it's still a risk. Even if you've done everything you can to trace rights holders, even if you've used the disclaimer. There are a number of factors which will come into play. For example, the nature of the use you're making, the choice of Creative Commons license that you've selected. Now, the more open the Creative Commons license you do choose, there are a number of ramifications. Number one, the more open, the less likely it may be that all rights holders will give you the permissions that you need that are compatible with the openness of the license you've selected. The second issue, of course, is that the more open your license is, potentially the greater the risk if you are making accessible or reusable and repurposable material for which you haven't sought third-party rights. Now, in order to help you, the OER IPR support project is currently working on a risk management wizard which will act as a calculator to give you an indicative level of the type of risk that you may encounter in situations where you can't clear the rights, maybe because the rights holders are either unknown or you cannot trace them. And this will be made available to all OER IPR projects in the forthcoming months. But for the time being, there are some important factors, as stated here, that can help you understand the types of levels of risk that you may be encountering. So what are some top tips to help you when you're thinking about your rights clearance for your OER? First of all, choose your Creative Commons or similar open content license first. Then you can make sure that the rights that are coming in are compatible with the rights going out. Ideally, your OER should be reusable and repurposable. Now, there are going to be some circumstances in which this isn't possible. The How Open are Open Content licenses available on the OER IPR Support IPR Starter Pack will be able to help you understand some of those situations, and you can certainly talk to your Strand manager in circumstances where you don't think your OER can be reusable and repurposable. For example, it may be because you have selected a Creative Commons license with either a non-commercial, an NC, or a no derivative, an ND restriction. Give yourselves lots of time to clear permissions. It will take you time to get the permissions you need. As I said earlier, the more open your open content license, the more likelihood that rights holders may need more convincing, or there may be required extra negotiation to seek the permissions that you need. As we saw earlier in the presentation, it's likely that any content that you may wish to use may comprise of layers of rights. In other words, there may be different elements you need to identify, different rights holders whose permissions you need to seek. Be flexible. You can use different types of Creative Commons licenses for different elements of your OER. Now, remember at the same time that this can be complicated and complex for your users, but it is possible. Finally, we are there to help. We're busily creating resources as we speak. We're creating some flowcharts which will be available really soon. We've got a Creative Commons compatibility wizard in the making, which will be able to guide you through the differences between the different Creative Commons licenses, and also to ensure that any Creative Commons license that you select to make your OER accessible by end users is compatible perhaps with pre-licensed Creative Commons stuff. We're also creating a risk management wizard which will help you understand and calculate the different levels of risk in your OER as an indicative value. We're also generating a paper on the strategic management of IPR in your institution. So there will be lots and lots of stuff coming downstream, so do keep in touch with us. We've got a blog, we have the GIST Legal Help Desk, where you can get help within a few days if you have a specific inquiry about OER, and we're creating and generating FAQs as we speak. We hope this has been helpful. Apologies for the Illuminate session that didn't quite turn out as I had hoped today, but I hope that this little audio extra on the presentation gives you just a little bit more content in order to understand some of the issues with regards to your rights clearance, some of the IPR issues and licensing issues that you may encounter.